of the Subcommittee on Public Works is hereby called to order. May I ask the Committee Secretary to acknowledge our guests and resource persons attending today.
Thank you, Mr. Chair. May I acknowledge the presence of the following resource persons. From the Department of Public Works and Highways, we have Undersecretary Anne Charlene G. Lapus, the Undersecretary for Legal Service. Attorney Michael Balodia Tupas, the Officer in Charge, Internal Affairs Division, Legal Service. From the Department of Justice, we have State Counsel Albert Ignatius Abragan. From the Department of Environment and Natural Resources, we have Engineer Bienvenido Cruz and Technical Assistant Luis Paulo Masangkay. From the Department of Transportation, ASEC Leonel Cray de Velez, the Assistant Secretary for Planning and Project Development, together with Attorney Nicole Alpiler, the OIC Chief, Rail Right-of-Way and Site Acquisition Division. From the Department of Interior and Local Government, we have Division Chief Cheryl Agustin Flores, together with Engineer Paul Joseph Fabito and Attorney Leo Angelo Menguito. From the Department of Finance, we have Attorney Ralbert Jan Neil Tibayan, Attorney 3 of the Legal and Legislative Division, with Attorney Scranton Orculio, Attorney 2, and the Project Manager, Attorney Rafi Gina, and Director Ricardo Bobis of the BLGF. From the Department of Budget and Management, we have Attorney Tricia Baraan, Director 4, Ms. Susan Faye Buffet, Budget Management Specialist. From the National Economic and Development Authority, we have Undersecretary Crystal Uy, USEC for Legislative Affairs, together with Mr. Paul Andrew Tatlong Hari, Officer in Charge, Assistant Director for Monitoring and Evaluation Staff. Mr. Renz Mark Garcia, the Chief of Economic Development Specialist, NEDA Infrastructure Staff. From the Human Settlements and Urban Development, we have Project Director Mary Ann Policarpio and Attorney Alvin Geolagon. From the Office of the Solicitor General, State Solicitor Vanessa Jacob and Katrina Dato, the Senior State Solicitor. From the Land Registration Authority, Attorney Gerardo Sirius is represented by Attorney Salvalente Tadeos Elizalde, the Acting Director for Legal Service. And Attorney Mark Geronimo. From the Metropolitan Manila Development Authority, USEC Romando Artes is represented by Attorney Rian Bautista, the Attorney 3 of Legal and Legislative Affairs. From the National Irrigation Administration, Attorney Riza Ibanez, Attorney 4 of Legal Services. From the Public-Private Partnership Center, we have Attorney Jeffrey Manalo, Deputy Executive Director, and Ariel de Los Angeles, the Planning Officer. From the National Commission on Indigenous Peoples, we have Attorney Rizabel Madangeng Aguilar, the Chief Legal Affairs Office. Together with Ms. Glenda Pua, the Chief of the Office on Socioeconomic Services and Special Concerns, and Mr. William Degiem, the Development Management Officer 3 on Ancestral Domains Office. And also, we have Engineer Teodorico Encarnacion, Infrastructure Advisor of the UPPAF Respond Project, and Ms. Annabel Herrera, the Right-of-Way Specialist, also from the UPPAF Respond Project. That's all, Mr. Chair.
For today's hearing, the committee will discuss the legislative measures on the amendment to Republic Act number 10752 or the Right-of-Way Act, House Bill number 6751, an act providing additional guidelines in the acquisition of right-of-way site or location for national government infrastructure projects, amending for purpose Republic Act number 10752, otherwise known as the Right-of-Way Act, Senate Bill number 1537, an act amending Section 5 of Republic Act number 10752, otherwise known as an act facilitating the acquisition of right-of-way site or location for national government infrastructure projects and for other purposes. Senate Bill number 2718, an act instituting reforms in the acquisition of right-of-way for infrastructure projects by the national government and by public service providers, amending for the purpose Republic Act number 10752, otherwise known as the Right-of-Way Act. Senate Bill number 2765, an act providing additional guidelines in the acquisition of right-of-way site or location for national government infrastructure projects, amending for the purpose Republic Act number 10752, otherwise known as the Right-of-Way Act. At this point, please allow me to make specific House rules to ensure the orderly and efficient conduct of the hearing. Can the committee secretary inform today's attendees of our House rules?
Kindly mute your microphone if you are not recognized. Since the chair cannot see everyone at once, feel free to get his attention by specifying your name and that you have something to say.
Kindly ask for permission first from the chair to be recognized before speaking. Improper behavior will not be tolerated by this committee. Before we proceed with the hearing proper, may I ask, make a question later. I will ask a question later when my colleagues are here. So at this point, we proceed with the public hearing for the amendment to Republic Act 10752 or the Right-of-Way Act. Delays in infrastructure projects are often rooted in the delays of right-of-way acquisition. Nung ako po ay secretary, ang favorite saying ko po ay if you deliver the right-of-way, we can deliver the project right away. So when I was secretary of DPWH, I encountered multiple delays in many high-impact infrastructure projects under the Build program. It was a recurring problem through my tenure as secretary. It was something that we had to meticulously deal with through several department orders based on the Right-of-Way Act every time we were pursuing a project. As a result of these expanded procedures, we are now able to enjoy several high-impact infrastructure projects such as the Metro Manila Skyway Stage 3. NLEX Harbor Link Segment 10 and the NLEX SX Connector. And I'd like to welcome my colleague, Senator Robin Padilla, to the committee hearing. Thank you for your time in joining us. And with the presence of Senator Padilla, I declare the presence of a quorum. Sige. Mahirap po ang proseso ng acquisition of right-of-way na talagang nakakaapekto sa timeline ng ating mga projects. For example, it took 6 presidents to complete Radio Route 10, a 9.7-kilometer expressway from Delpan Bridge, Tondo, Manila to the mouth of Malabon River at Bangkulasi Bridge in Navotas City. We need to make significant tweaks to the current law in order to make it responsive to the needs of the implementing agencies. It is crucial to know how the Right-of-Way Act could be amended so it would be in sync with the dynamic changes in our infrastructure landscape. We also need to ensure that the implementing agencies will be empowered to fulfill their mandates once the law has been amended to fit the contemporary needs. Additionally, I am also looking forward to how we can harmonize and align the Right-of-Way Act with recently legislated related measures such as the RP-VARA and the PPP Act. Apart from this, kailangan din natin masigurado na itong amendment sa Right-of-Way Act will solve the compensation issue of private property owners affected by government infrastructure projects. We must ensure that moving forward, they will be provided with timely and just compensation. The just compensation is a time-honored principle enshrined in our Constitution. At kailangan natin masiguro na makukuha ng ating mga affected kababayans ang worth ng kanilang properties. We must develop our infrastructure landscape, but of course not at the expense of our fellow Filipinos. As the former infrastructure czar, Naniniwala po ako na solving this bottlenecks right of way acquisition will give us high impact infrastructure projects that are delivered timely and efficiently. Gamit ang solusyon na ito, mabibigyan po natin ang ating mga kababayan ng mga proyekto na makakatulong sa kanilang araw-araw na buhay at sa ekonomiya ng ating bansa. To start, at this point, we can start with the presentation. So, meron po bang mga presentations? Yes, please proceed, sir.
Good afternoon, Mr. Chair. The Department of Transportation has a presentation regarding proposed amendments to the Right-of-Way Act. Mr. Chair, if it'd be allowed for me to speak to the Secretariat for them to flash the presentation of the Department of Transportation. Good afternoon, Mr. Chair, senators, and other members or attendees of the committee. Essentially, while the DOTR has several amendments that we proposed in our position paper for today, just for the highlight of the committee, we would like to highlight particularly our request for amendments to the subterranean right-of-way for subway projects. I believe everyone is aware that the Department of Transportation is building the Metro Manila subway project. We'd like to emphasize and repeat that this will not be the last subway project, and our proposed amendments to the Right-of-Way Act. With that, we hope to build even more subways, not just in Metro Manila, but also in our other urban centers throughout the country. Next slide, please. Next slide, please. Thank you. Just to summarize, our proposed amendment to 10752 is to reduce the depth of the subterranean right-of-way from 50 meters, 50, to 15 meters from the surface. This will essentially allow the Department of Transportation and other government agencies to build more subterranean infrastructure. Next slide will show our two main reasons. One is to future-proof our infrastructure planning and infrastructure development, particularly with mass transportation systems, as well as improve and enhance safety for those passengers who will be using those subway systems. So we will give some examples. Next slide, please. I think we're all familiar, for example, or some of us might be familiar with the subway system in Tokyo. This is a very 2D map, but actually the real situation here is next slide. We can see the 3D map of those subways. Originally, Tokyo had few railway lines, subterranean railway lines, but over time, as their network grew, they had to dig deeper and deeper underground. It's hard to see it here, but I think the next slide will showcase the depth over time. So on the x-axis, we have the years. So the first subway of Tokyo was built in 1935, the Ginza line. That was around, this is from the Japan Ministry of Land, Infrastructure, Transport, and Tourism. The Ginza line was 16 meters underground. This was built in 1934. As we know, World War II happened, so they didn't build a subway line. The next subway line that they built, 17 meters underground, the Marunouchi Railway Line. And over time, as their subterranean space was used for subways, they had to build subsequent subways underground, even further underground. Their most recent subway line is the Oedo line. You see that on the bottom right. That was in 2000. And the depth of that was 49 meters. We would like to note that that's actually less shallower than what we currently have in 10752, which is 50 meters. And since we are not here yet where we have several subway lines, but this is where we want to get to, we need to start shallower. And this is why the Department of Transportation would really want the amendment considered for a shallower depth for our subterranean right-of-way from 50. Again, 50 meters even from Japan is very deep. But we would like this raised to around 15 meters. Next slide. So this is regarding the future proofing of our subway systems. But I guess one of the other major aspects that the Department of Transportation wants to ensure when it comes to our current and future subway lines is the safety of passengers. The depth of our subways or our subterranean infrastructure doesn't matter if it's for a sewage line, electricity, gas, they don't care. But when we have to evacuate live passengers, persons with disabilities, senior citizens, it matters to evacuate them from underground. Right now, a 50-meter evacuation, for example, wouldn't matter if it's above ground. A 50-meter building would be around 18 stories. Uh, Going downstairs isn't as challenging as evacuating going up. So we want the depth to be shallow to make sure that we're able to evacuate our passengers safely. So we do have some standards that we look at, especially when we're building our current subway line. Again, a good reference is the Japanese standards. So they have standards, for example, for the safety of evacuation of passengers. The next slide will be a bit technical, but essentially how we measure evacuation for subterranean infrastructure is in a matter of minutes. So in this case, for example, we do want to be able to evacuate people around 6 to 10 minutes when there's an incident. That's the safe margin usually. Next slide again showcases the future of our subway systems here in the Philippines. We are intending to build subways in Cebu, in Metro Cebu. We have the Metro Manila subway. That's actually only phase one, what we're building right now. We're already preparing for phase two. We have MRT4, MRT5 here in NCR. We're looking at the Alabang Zapote secondary line. I like to add here the Mindanao Railway projects, both phase one in the Davao area and phase three in the Cagayan de Oro area. We're currently discussing with LGUs in Cagayan de Oro Metro. And here we are seeing that we do have to tunnel also in the downtown area because, as we know, the above ground uh, uh, urban area is already built up. So as we develop our cities, as we grow economically, it becomes very surface right of way becomes very valuable, and maybe the only option for us is truly to go underground for subways.
Just a reminder, sorry to interrupt. Just a reminder, maybe some details we can discuss in the technical working group. We can be siguro medyo mas broad na lang yung presentation natin. But kasi after this we will break up yung technical working group. Or we can go deeper into the details. Thank you.
Thank you, Mr. Chair. I guess I just have 3 last slides, which I'll run through really quickly. The next slide are examples from other countries. Next slide, I think in Singapore, they recently amended their right-of-way law so that 30 meters and below would go for government subways. This is also because Singapore has built several subways already, and they have to keep going deeper when they want to build more subways. Next slide, we have some examples from Europe. Helsinki, actually, it's around 6 meters. And then the last slide in Montreal, I think it's actually, next slide, 10 meters underground. So it varies, Mr. Chair. And that concludes our presentation from the Department of Transportation.
Thank you.
Thank you.
Are there other presentations or just one? There's a DPW. May presentation po ang DPWH, correct? Is there?
Mr. Chair, we have with us this afternoon our written position paper for the proposed amendments to the Right of Way Act. In summary, Mr. Chair,
You can summarize.
we
Yes.
can mention that the comments contained in our position paper is themed around the current conditions on the field and the reality that right-of-way funding is really very limited for DPWH. So in our list of recommendations here, Mr. Chair, everything is geared towards maximizing the allocation for right-of-way acquisition and streamlining the process of right-of-way acquisition. Because as it stands right now, Mr. Chair, the entire right-of-way acquisition process will take at around 2 years. 1 year for, ideally, for the preparation of the right-of-way acquisition plan, and then the right-of-way acquisition process itself, Mr. Chair, can take about a year or 6 months to a year, under ideal conditions. So one of the challenges that DPWH is facing is the validity of the fund for the right-of-way acquisition. Under the cash-based budgeting, the validity of the fund is 1 year to 2 years. And under the DBM guidelines, the right-of-way funding is not among those classified for comprehensive release, meaning it is not released immediately upon the effectivity of the GAA. It is for later release. We are dependent on the issuance of the SARO, which this year, Mr. Chair, came at the later part of the first quarter. So it is really a challenge to comply with the requisites in order to disburse the funds.
So USEC, so you're saying USEC that the provision where the DPWH or the relevant government agency is required to finish a right-of-way plan prior to implementation may not be realistic. Kasi, and I can vouch for that also from personal experience that sometimes in budgeting there are items that were not part of the original NEP that were amendments, so they were not the necessary preparations were not made because you cannot anticipate what will come out in the GAA, and you can only recommend. So I understand that point, and I think we should all, the committee should take notice of that. An ideal world, yes, we should have a plan, but at the same time, we should be a little flexible because you have to award it within a year, and you have to implement it within 2 years, diba? Yung so your point is well taken, and we should note that in the committee. I think the point of USEC, Lapus, is very well taken. So that's correct. I assume that's what I was gathering from your statement, that this what would you propose as an alternative?
Mr. Chair, first of all, I would like to extend our appreciation to this committee for considering our initial recommendations to the proposed amendments of RA 10752. Maybe a few points, Mr. Chair, for emphasis, in line with our advocacy to maximize the budget for right-of-way funding is maybe in coming up with a standard value for the price or offer for the purchase price of the right-of-way acquisition.
Have you studied how the RP? Sorry, excuse. Have you studied related to that the RP Vara? As have you studied that and its implications toward this law?
Yes, Mr. Chair. In summary, the RP Vara is a good law. It will provide a standard value that may be used by all government agencies, for DPWH for right-of-way acquisition in the appraisal, and other government agencies for taxation purposes. With respect to right-of-way acquisition, Mr. Chair, we will be able to use the standard value provided under RP Vara for right-of-way acquisition. It will limit, or it will lower our cost for acquisition because we will no longer be required to purchase or procure in the independent property appraisals. And we will no longer be required to engage the services which requires costs for GFIs. So if we have one standard value, Mr. Chair, it will be easier because it will lessen the time because we will no longer need to procure IPAs and GFIs. So it is a good law. However, it is still in the process of issuing and implementing rules and regulations, which I understand, Mr. Chair, will take about 2 years so that the law will be effective. In the meantime, DPWH is coming up with interim measures to address the gap with the issuance of the RP Vara. But DPWH is really very appreciative of the RP Vara, Mr. Chair. So we also propose that we adopt it in the amendments of the Right of Way Act.
Yes, thank you. And I have Also, before we move, I'd like to acknowledge the presence of our majority floor leader, Senator Tolentino. Thank you thank you, Mrs.
Just a quick retort.
Yes, we recognize, the chair recognizes Senator Tolentino.
Chairman, I just overheard something. It will take you 2 years to craft an IRR. That's more than half the life of a congressional term. Ganun katagal ba ho gawin yun?
Mr. Chair, I stand corrected. Not only the IRR, the scheduled market values under the RP-VARA law will require consultations and public hearings. It is outlined under the law po that the whole process will take about 2 years po, excluding the time for crafting the IRR, which will take about 6 months.
Is
6 months.
a period and you can go faster, not
Ah,
so you intend to complete that not within but at par with the deadline.
Mr. Chair, the coming up with the schedule of market values is an interagency collaboration between LGUs, the Department of Finance, and the BIR, as I understand. Timelines have been set under the law, Mr. Chair.
Can we request the DOF? Maybe you can comment on this this possible timeline for the reconciliation between the RP-VARA and this law.
Yes, Your Honor. We're presently crafting with the BR the rules regarding the RP-VAR.
What is your timeline?
Your Honor, we intend to submit to the Secretary the draft IRR by October.
Over, not 2 years.
The IRR, Mr. Chair, will be ready in October, but the updating of the schedule of values itself, Mr. Chair, will take about 2 years as provided under the law.
Other questions? Just came here to provide you additional quorum support, Mr. Chairman.
Thank you.
And thank you for being a very active Deputy Majority Leader.
Thank you.
And belated happy birthday as well.
Thank you.
Birthday niya kahapon eh. Kaya wag niyong pahirapan yung chairman ko ah.
Thank you very much, Senator Tol. And I also have a question regarding the if with the RP-VARA once let me go back to the subterranean for a moment. I'm curious about, and this is a technical question, hindi ko lang alam kung alam mo yung sagot sa tanong ko. But anyway, I'll ask it. In terms of ano pong effect sa, halimbawa, ako yung may-ari ng lupa at 15 meters na yung, what does that preclude me from putting up a building? Ano bang magiging effect sa property owner?
Mr. Chair, with regards to the ability to build on top if there's a tunnel. So the tunnel has, if we build a tunnel, say the tunnel boring machine, there is a load that that tunnel can support. There are examples where we've tunneled and then we can build a building on top of that. So I guess the limit will be the load that the building will have. So if it's a single-story building, it should not affect it. But if it's a high-rise, I think the tallest building in the Philippines right now is the one in the Grand Hyatt that's 300 meters. It would be difficult to build that with a subway tunnel. Now with the subway naman, sir, with the tunneling, we will not touch any existing structure. And as much as possible, we will still try to utilize public right-of-way. However, there are instances where we do have to tunnel underneath private properties.
Yes.
And in those instances, we try to minimize the impact to potential high-value structures. Especially, so it depends on the zonal zoning. If it's commercial compared to low-density residential, for low-density residential, it should not affect the ability to build pretty high. But for the exact technical standards, sir, yes, we would have to get back to you on the TWG for that one because it differs from
Yes,
place to
kasi I
place.
can foresee, siguro baka magkaroon tayo ng maraming scenarios like idadaan natin, baka may existing building na. And even though it's 40 meters, baka may effect din sa structural integrity ng building. So ano maging compensation ng building owner kung hindi siya papayag, or pwede ba natin pilitin yung owner na maglagay ng subway sa ilalim niya? So, I mean, maybe you comment some scenarios.
Yes, sir. If it's an existing building, we
Yes.
are able to tunnel. And so long as we don't impact the foundations, that means we have to go deeper than the foundations. But it's going to be very difficult to look at future construction. What we're doing right now for the subway project, if there is existing foundations, we avoid it. So for example, we are tunneling under gas stations. So we're lower, for example, than the storage of the fuel. So there is a it's the technical terms are it's 2.5 times the radius of the tunnel is usually your easement from the nearest foundation. So I guess we'll bring in also perhaps some of our Japanese engineers here.
And I
But
think
there is ways for us to tunnel underneath.
yes,
existing
and I think
structures.
for future we should also have representatives from the real estate sector, so they can also comment. Some specialists, maybe some engineering specialists, so that we can also anticipate any possible scenarios in the future. Should we lower the threshold for subterranean right of way? I think it's a very technical question to answer. So I would, if I can, I'd like to direct the committee in the future. We can invite some technical people, and maybe some representatives from people who build. I don't know, siguro mga developers also, yung high-rise developers who might be affected. But I remember when I was secretary, usually hangga't maaari talagang dinadaan nila sa ilalim ng kalsada, public road. Hangga't maaari. I remember with the subway, it was under C5. So I know, but like you said, there will be some cases probably that will require boring underneath a structure or on a private property of an individual. So I think we have to just anticipate different scenarios in the law, and we can take that up in the technical working group. Yes,
One question
Senator
address this
Tondino.
to the Department of Justice. You answer this. How can you reconcile this the statement just given by ASEC Veles with section 437 of the Civil Code of the Philippines, which states that the owner of a parcel of land is the owner of its surface and everything under it, and he can construct thereon any works or make any plantations and excavations which he may deem proper, etc., etc.
Yes, Your Honor. Good morning. Good afternoon, Mr. Chair, Your Honor. Yes, Your Honor. The owner of a property, his ownership would extend to the subterranean as well as the aerospace, Mr. Chair. So, if the subterranean is affected, then he is also entitled to just compensation, Mr. Chair.
Just compensation prior to the tunneling, and even just compensation as regards damages brought about by the tunneling, vibrations, etc., etc. Looking forward.
Mr. Chair, in case of expropriation, may I defer to the OSG, Mr. Chair? This is within the sphere of their knowledge and expertise. Thank you.
So OSG, please. Yun.
Yes, Mr. Chair. Mr. Chair, if you could kindly repeat the question.
Has something to do with the implications of Article 437 of the Civil Code of the Philippines. The owner of the surface is the owner of the subsurface, and he can do anything, any construction beneath the surface.
Yes, Mr. Chair, in fact, rendered a legal opinion to the DOTR regarding the provisional deposit on subterranean acquisition, Your Honor. And in that, Your Honor, we cited several cases. One of each is the National Power Corporation versus Ibrahim, where the Supreme Court, the High Court, applied Article 437 and awarded just compensation to the private property owner for the tunnels built by the Napocor, Your Honor. We also cited the Department of Justice Opinion number 043, series of 2014, which says that any impairment to the enjoyment of the property, whether surface or subsurface, shall cause the property owner have rights to just compensation to the actual value of the property subject to rules and regulation and as determined by the competent court. However, we concluded in that legal opinion that for purposes of provisional deposit, the jurisprudence as well as the Right to Pay Act and IRR of Right to Pay Act is actually silent. So we suggested,
Interrupt you.
yes,
With the permission of the chairman, isang tanong na lang po. So halimbawa po ito yung surface. Nag-tunnel dito. That's your Supreme Court decision. Article 437 states that the owner of this surface is the owner of the subsurface. Nag-tunnel dito sa ilalim, just compensation. Can the owner now dig beneath the subsurface below the tunnel? He's still the owner of that. Yung just compensation hanggang doon na yun sa ilalim, dito lang yun, dinaanan ng subway, halimbawa, yung ilalim.
Mr. Senator, to be candid, the jurisprudence does not touch upon that subject, and I think it's a quite a complicated legal issue that needs to be studied deeper, Mr. Chair, because for the first time we are having subway projects in the Philippines, and that matter has not been discussed or even brought to courts before, aside from this very first case of Napocor versus Ibrahim, Your Honor.
It as well include that in your proposed IRR. Nothing can prevent the owner of the surface from touching the subsurface, even though a right of way was given beneath the surface. Very, very technical indeed. Pinaalis ko lang yung antok nyo. Thank you.
Thank you. Salamat. Legal luminary. Thank you. And I hope that we contemplate, because Senator Tolentino is our resident legal luminary in the Senate. So, like I said, it goes back to what I said earlier, that this is, like you said, this is the first time that we'll be building using subterranean in an extensive manner. It's important that we tackle all these scenarios, like what Senator Tolentino said. Halimbawa, okay nga, paano yung ilalim? Under 10752, 50 meters. But there are other provisions in the law, in the Constitution, that give rights to the landowner. So how do we reconcile that? That's an interesting legal issue. Hindi naman ako lawyer, so DOJ, OSG, kayo ng mga legal sa gobyerno, dapat kasama yan sa pag-uusapan sa technical working group. And moving forward, I'd like to, I remember when I was, nung ako po yung secretary ng DPWH, isa sa mga naging problema namin was the I think one was the appraisal. One constraint was the speed of the appraisal process, because obviously the limited din yung capability ng land bank, limited yung capability ng GFIs. So minsan sa dami ng mga cases, sa dami ng mga appraisals, doon hindi na parang nade-delay yung project dahil hindi makuha kagad yung mga appraisal. So paano ba to ina-address ng right of way law? Does anyone, attorney, can anyone answer? Yes, whoever can answer, please. Attorney Lapus. Sorry, Undersecretary Lapus.
Yes, Mr. Chair, under the proposed amendments, there are several schemes proposed to, one is the RP Vara, the proposal to include the schedule of market values to be considered as the purchase price for the lands to be acquired for right of way would be helpful, because that will eliminate the requirement for the procurement of independent property appraisers and the engagement of GFI. So if we have one value that will be followed by all, that will be the basis of the offer, Mr.
So
Chair.
there will no longer be an appraisal. So the only value you're proposing under the law, that the only value that will be used is the one that is established by the RP Vara. Kasi right now, when we expropriate, we deposit the zonal value to the courts, correct? And then once we deposit the zonal value to the courts, while they're determining the appraisal, the value of the property, they'll give us the writ of possession. So how would this change the dynamic? What is your proposed? Do you have something? Okay, please, Yusek Uy.
Thank you, Mr. Chair. Actually, so we understand that of course, it's very important that we integrate our PIBARA already in the way that we value the property. But we're not just talking about land. We're also talking about improvements, as well as the replacement cost of structures and improvements, even market value of crops and trees, and other appropriate compensation. So I don't so we still foresee the need to include independent property appraisers, but it's just a matter of I guess the current law is very limiting in the way that it only accredits certain institutions to do the accreditation. So we can have more flexibility with respect to that. With respect also, I would just like to flag also for the other appropriate compensation. There are several versions that includes many different categories for these types of additional compensation. So like for example, disturbance cost or income loss or even transportation cost, if I remember correctly, I think in the House version. So that's something that we can discuss in the TWG. What would be a reasonable inclusion of the category of the appropriate compensation?
Yes, and perhaps even and I don't know, this is something you consider that also this is related to the presence of informal settlers in the properties, which of course under the law technically they're not entitled to any. They're not, obviously they don't have ownership, but nevertheless, perhaps for humanitarian reasons, we can see how we can implement some sort of I guess. And I'm not sure, we have to look into this, and this is what we can discuss in the technical working group. But taking that into account for humanitarian reasons, what sort of compensation that could be given to those informal settlers for humanitarian reasons. I mean, when you talk about flexibility, perhaps that can be included in the flexibility that's given to the implementing agency. I think. I mean, Yusek, if you have any comments.
Yes, Mr. Chair. In relation to the values under the RP Vara mentioned earlier as to the replacement cost, actually we welcome the development that it is proposed that under the RP Vara, the replacement cost shall be based on depreciated value, which is in line with our proposal to make it a little bit cheaper for right-of-way acquisition. Because as the law stands right now, replacement cost is based on the value that is required for the owners to be able to replace the value in present date values. So if we are going to follow the proposition under RP Vara, depreciated cost, so its right-of-way acquisition will be cheaper. Another point, Mr. Chair, is in relation to sorry, I forget my point already, but maybe later I'll remember. Oh, yes, Mr. Chair. Foreign funded projects, sorry. For foreign funded projects, we've observed a discrepancy between our local laws and our loan agreements in foreign funded projects. There's a list of entitlements under foreign funded projects which is not supported by our local laws, which is the Right-of-Way Act. So we are at a quandary as to whether we will disburse these entitlements in foreign funded projects because it has been a source of COA observations, Mr. Chair. So we propose to standardize the entitlements, and we support if we are going to expand the entitlements under the amendments, Mr. Chair.
That's a very good point, and that's very those are one of the the scenarios that on the ground we've experienced, but it's not provided for. So I think this is the technical working group will be a very good opportunity for us to bring out all these issues and include it in the bill once and for all. Kasi I know we've experienced all these issues. Iba naman yung technical, iba naman yung theoretical sa nakikita natin on the ground. And of course, kailangan din natin alagaan yung mga kababayan natin na syempre meron din minsan may mga informal settlers at hindi rin natin pwedeng pabayaan ang mga nakatira doon. Kailangan kahit papaano may flexibility tayo para mabigyan naman sila ng compensation para sa mawawala sa kanila. So anyway, yes, Asek, you have a statement to make.
Mr. Chair, regarding the question regarding the appraisers, so right now the Department of Transportation does use our GFIs to do the appraisal services for our infrastructure projects. And we're quite satisfied with the services of Land Bank and DBP. However, we would like to further capacitate them so they can do even more, because at the rate that we're going with the build, and build better, more program, they might have to increase their sizes, or they can subcontract with third parties. But DOTR is quite happy when we receive the appraisal reports from other government agencies, particularly the GFIs, as the basis for the compensation for either landed individuals or even for structures by informal settlers.
Yes, I agree. I mean, to be fair to our GFIs, they've done, even during my time, they did a very admirable job of expediting the appraisals. But nevertheless, like you said, we want to capacitate them further because we only expect we expect increase in our requirements for the build better more. So that being said, I think we should anticipate that we need perhaps if there's something that we can include in the law that would capacitate them further, that would give them further support. I think that would be helpful to our implementing agencies. At the same time, I remember another issue would be with the OSG. We had, of course, the lawyers. We had to deputize, I think, some lawyers also before, just to expedite the right-of-way cases. Again, the OSG did a very good job. But if there's a way that we can help them make the job easier and make them be able to have a higher capacity, maybe that's something that you can also recommend based on your requirements. You would know your capacity. So if there's something that we could include in this law that would help you implement even faster, because of course you're the one. Usually, ultimately it's the OSG who will process all these expropriation cases. So we used to have meetings consistently with the OSG team. If there's something that we can do to help from a legislative perspective, also perhaps support to the agency itself, the OSG, please, maybe we can include that in our discussions. Maybe you can already think about something that we can possibly include in the law that might assist the OSG. Yes, please.
Mr. Chair, we appreciate the acknowledgement of the good senator about the predicaments of the OSG in handling expropriation cases, and we will bring this matter to the attention of the Honorable Solicitor General for further comments, Mr. Chair.
Thank you. And yes, Yusek.
Yes, Mr. Chair, we affirm the observation of the chairman with respect to the services being rendered by our council, Mr. Chair. In fact, DPWH would like to further enhance this collaboration with the Office of the Solicitor General. We have a proposal for an executive order which would allow government agencies undertaking right-of-way acquisition to collaborate with the Office of the Solicitor General by deputizing some of the lawyers of the agencies conducting the right-of-way acquisition at certain stages of expropriation proceedings. This will maximize the budget for logistics, Mr. Chair, like for simple proceedings, like for pre-trial in the expropriation proceedings, non-controversial stages of the expropriation proceedings, we are proposing that government agencies be allowed to be deputized by the Office of the Solicitor General so that we can collaborate and maximize the manpower that we have, the lawyers of government agencies, Mr. Chair.
Yes, I think the agencies can be a big help. I think we've done it before, but it's not institutionalized. So maybe it would be helpful to include it in the law so that it's, and perhaps if there are provisions that can allow more flexibility with regards to the use of resources of the department to help, siguro it can be clarified in the law. I mean, there's nothing that says you can't, but there's also no, it's not part of the, I guess it's not part of, it's not mentioned specifically in the law. Maybe there's something that we can, maybe you can propose something in addition to
Yes,
what
Mr. Chair, we have a draft executive order. Maybe we can propose it also to be
as part of the
included
law.
in the
Yes.
law. It's
Yes.
subject to comments of the Office
Yes,
of the
yes,
Solicitor
yes. I
General.
think that would be if you can, if we can furnish the OSG with that proposal, and if it's something that we feel the committee feels can be helpful, then let's include it in the law. I think that would be. Would you like to comment on the statement of USEC?
Yes, Mr. Chair, we have in our law the power to deputize government lawyers from the other agencies. But it would be appreciated if the USEC, the good USEC from the DPWH would furnish us a draft of the EO. Thank you.
Yes. So please.
Mr. Chair.
Yes. Yeah, so at this point, there are a lot of technical issues. We don't have to get into it now. But is there anything else, anyone else who wants to make a statement to the committee regarding their...
Permission to be recognized, Mr.
Yes, sir.
Chair.
What is your name?
I am Attorney Salvalente Elizalde from the Land Registration Authority.
From the land registry. Yes, sir. Please proceed.
Yes, Mr. Chair. We have a comment here. After reading the drafts of the Senate bills, at least two of them, Senate Bill number 2718 and Senate Bill 2769, has certain stipulations which appear to amend Section 5 of Republic Act 10752. Our comment is that the statement essentially says the implementing agency or the private entity shall cause the annotation of the deed of absolute sale on the transfer certificate of title. Our concern is, first of all, why just an annotation? Why not, sir, registration for the issuance of a new certificate of title? Why just mere annotation? The annotation certainly would be noticed against the whole world, but wouldn't it be better for the government if we if we cause the registration of the sale so that new titles may be issued?
Okay, attorney, attorney, would you like to comment?
Yes,
USEC,
Mr.
sorry.
That is
USEC.
my first question.
Mr. Chair, may I respond to the point? I support the proposition that it should be transferred, Mr. Chair, because it will be to safeguard the property of the state after we've acquired the property. So it has to be transferred really in the name of the Republic of the Philippines. However, Mr. Chair, the provision that provides for just annotation, I think was sourced from practices because we are trying to limit the costs, because when we transfer, there are costs additional to the right-of-way acquisition, which includes transfer fees, taxes. In which case, Mr. Chair, we propose that those costs be, we exempt the government from those costs so that right-of-way acquisition will be cheaper, because there would be times, Mr. Chair, that we will be penalized by BIR because we have not been able to submit the deed of absolute sale on time, or we have not transferred it on time, which sometimes, Mr. Chair, are due to uncontrollable reasons of the or not attributable to the agency, which the penalties can be really expensive, Mr. Chair.
Thank you. That's another example of on-the-ground realities. But sir, you have another question. Yes, please continue, po.
Yes, Your Honor. The second one would be that the annotation XXX of the deed of absolute sale on the transfer certificate of title, uh, there we have to remember it is not, we just don't have transfer certificates of title. We have original certificates of title. So what the LRA would like to propose would be that you amend this to certificate of title na lang, so that it would be covering the other kind.
Very good suggestion. We appreciate your agency suggestion, and definitely I think it looks like the DPW is amenable to that, so we can thresh that out in the technical working group. I'm sure. It looks like I think we just have to balance out the practical concerns of the department with your, of course, your expertise in the issuance of titles. So yes,
Thank
we
you,
can
Your Honor.
address that, and I think are these included, sir, in your position paper?
Your Honor, we submitted an advance copy,
Okay.
but we would like to amend our position paper to be more
Yes, yes.
specific.
If you can, when can we, when do we need them to submit? Please submit your new position paper before August 27. Give us, if you can submit one prior to August 27, which is when we will hold our first technical working group, so we can consider that in the discussions. Thank you, sir. Is there any other agency that would like to make any comments before we proceed? Yes, Engineer Cruz.
Thank-
Yes,
Thank
sir.
you, Mr. Chair. There are instances wherein the affected area is just a portion of the big property. So if you will have it issued transfer certificate of title TCT, there should be a subdivision survey to be conducted in the area. So, for example, lot 1A, lot 1B, both of them will have a TCT. So this is in connection with the proposal of from our friend in LRA. Thank you, Mr. Chair.
Yes, thank you for that comment. And I believe the DPWH has a comment also. Yeah.
Mr. Chair, we just remembered that we are also encountering challenges with respect to untitled lands. And it is proposed that tax declaration be considered in addition to other evidence of ownership, which provides that there should be proof of utilization or improvements over a span of 20 years. It is ideal, we believe, however, on the ground, we find it difficult because sometimes this can be a source of spurious claims. By experience, Mr. Chair, tax declaration sometimes cannot be really reliable. And to support the claim that the claimant has been in possession for the last 20 years and that the claimant has been cultivating the property for the last 20 years will merely require the submission of a simple affidavit or a barangay certificate. Sometimes it can be a source of contention among claimants. And if the property becomes subject to litigation, right-of-way acquisition becomes longer, Mr. Chair.
Yes, actually, I think I touched upon that in my version. For the with regards to for untitled lands, because it's in many areas that's actually a very common occurrence, the untitled land. So definitely, I think I touched upon that about how to process. But certainly, I'd like to hear the comments of everyone so that we can streamline the process to make it faster. Definitely, that's something that we have to touch on, I think, during the technical working group. So thank you for that comment. Yes, sir, Engineer Cruz.
Thank you, Mr. Chair. Sometimes those untitled lands actually cannot be titled because they are inside forest land. So there should be a validation with the DNR if that area is within A&D. Otherwise, you will not have a problem if it is inside the forest land. Thank you, Mr. Chair.
Okay, thank you. Thank you very much. That's very helpful. Yes, ma'am. Ano pong, sir, from the LRA.
No. Good afternoon, Mr. Chair. From the National Irrigation Administration.
Okay, from the National
Yes, sir.
Irrigation. Okay, yes.
Just a comment to the point of Madam Yusek regarding untitled properties. In our experience, both in private and in NIA, the proof is only the tax declaration, but part of the supporting documents would be the certification from the DENR that these properties had been in the possession of. You can find that in the corresponding DNR offices within the jurisdiction. That's how we validate the possession of the current posing landowner. You can find it in the DNR because actually that's the concern of my family. We do not have titles in our family in titles in properties, but we are but my ancestors are registered under the DNR within the area. But another point, Mr. Chair, I just want to comment as to the annotation or just the simple annotation of the corresponding documents transferring or proving sale or transfer to the government. In our case, we usually need just a portion of from a big chunk of property. So instead of just like the sir from Engineer Cruz mentioned, if we'll just be needing a portion and it would be costing the government so much for the subdivision and acquisition of the title, it would not be let's simply put, it would not be what's this wise for the government to be spending so much for just a little portion. So we really move that the annotation be maintained. Yes, ma'am. You know, in one of the provinces in Region 1, the going rate for just a simple transfer is 30,000. And we only need 30,000 pesos. We just need a portion, let's say 100 square meters. And that 100 square meters applies to several kilometers po. So it's, and we only, uh, although it may be included in the budget that we will be asking the government, but just the same, it will still entail cost to the government, unnecessary cost. And we can protect the ownership or the right of the government over that chunk by annotation. We've done that before, Mr. Chair. So I don't think it is a foolproof means of ensuring or a safety measure for the government, just so we can save a little for other more important expenses with respect to project implementation. So on the part of NIA, we maintain it because that's what we have been doing, Mr. Chair. And also, just want to take advantage. Also, the under 10752, it says may utilize the services of GFIs and independent property appraiser. On account of that what we do in NIA is we establish a project valuation committee composed of technical people whose jurisdiction is within the field po. So we save a lot from no offense meant to to land bank and other property appraisers, but that's what we do. And based on the output of our project valuation committees, we have the same, if not exactly the same, but within a range of 5,000 less or less than that. So we get the same output or value of the property subject of right of way. So we save a lot, really. Again, we want to maintain that may be emphasized, be magnified, that may pertains to the implementing agency.
Thank you very much. I think they're a lot of very valid comments, and they're all very relevant, and a lot of it is based on really uh, knowledge on the ground from agencies who have participated in right-of-way proceedings. So I think it's good. I'm looking forward to a very productive debate when the technical working group comes, which will be on 27th, on Tuesday next week. So bring your best legal minds on that day, and let's have a healthy debate and share your experiences so we can craft a law that really expedites right of way. And I'll be prepared. I'm looking for this is a very important law for our country, especially as we know that one of the emphasis one of there's a large emphasis now on the infrastructure program of the Build Better More. So in order to support that, I think this law will be one of the key components of ensuring that that dream is implemented expeditiously for our country. So I hope that you all remember, you all update your papers, your position papers as needed, and of course. Before we end this hearing, I would like to reiterate the utter importance of what we discussed here today. More than ensuring that the implementing agencies are empowered and equipped with the necessary provisions to efficiently fulfill your mandates, kailangan din natin siguraduhin na ang mga proposed amendments sa Right of Way Act ay makakatulong sa ating mga kababayan. Lalong-lalo na po ang mga private property owners na naapektuhan ng ating mga infrastructure development plans. Just like what we talked about earlier, we must ensure fair, timely, and just compensation. Kailangan na maibigay natin sa ating mga kababayan ang value at worth ng kanilang mga properties. Kailangan maging fair din tayo sa mga property owners, sa ating mga kababayan. Kaya napaka-importante po na ma-craft na natin itong right-of-way law. Meron pong mga kaso ng delays of compensation to the point na hindi na nakukuha ng property owners ang worth ng kanilang properties dahil sa inflation and the decreasing purchasing value of their money. Bumababa ang value ng kanilang pera dahil din sa tagal bago maibigay sa kanila ang kanilang compensation. Ang mga properties na ito ay mula sa kanilang pinaghirapan, and it will be unjust that they will not be properly compensated. So through the amendments of the Right-of-Way Act, we want to make sure na wala pong madedehado na Pilipino dahil sa right-of-way acquisition. So again, sisiguraduhin natin na mabibigyan ang mga affected nating mamamayan ng just compensation at iwasan po ang unjust compensation. So again, thank you very much for your time here today. And on Tuesday, we'll begin another debate we'll go more heavily into the technical details. So please, when it comes to the subterranean issue, hopefully we have more technical information that we can discuss, and with regards also to the effect on the property owners. And the interesting point of Senator Tolentino regarding the legal rights of property owners should there be tunnel constructed on their property. So that's interesting. Support to we also have the points from the NIA and of course the LRA about the process of right-of-way acquisition, and of course DPWH, DOTR, who are at the forefront of the Build Better More campaign. So they really need this support from this legislation, and of course from those who are helping. Again, it's a whole community of agencies that need to work together in order for us to deliver the right of way. So it's important in our debate that you bring out all the issues, everything that we can include in the law that might help. Let us include it already kasi syempre mahirap din gumawa ng batas, and we just want to make sure na lahat ng kailangan natin isama sa batas ay kasama na paglabas ng committee report. So again, thank you very much for your time, and to all of you, thank you very much, and I'm very happy about the very productive and very relevant comments that you have made today. And of course, to my former colleagues, it's good to see you again. And I look forward to working with you to craft a very responsive law that is a priority of our president. So hopefully I'm very confident we will pass it very soon with your help, and I hope it will be a very productive piece of legislation that we will produce in the near future. Thank you very much. And at this point, I'd like if you have, I would, with the approval of my colleagues and in consideration of the time allotted in this hearing, I would like to adjourn our hearing and refer the measures to a technical working group. If you have any additional comments on any of the sections or provisions of the legislative proposals, please email them to this committee, and we would gladly welcome and review them. Also, if you have not yet if you have not yet submitted your position papers, kindly submit them no later than August 27. With that, thank you very much.